Hi, I'm attorney Renee Osipov with Chelle Law, and we assist nurse practitioners with employment contract issues. Today, I'm discussing if a 2-year restriction on a non-compete is reasonable. And before I kind of get into that, I'm just going to briefly go over what actually is a non-compete. So a non-compete clause is typically listed in your restrictive covenants in your employment agreement or contract. And the non-compete clause is to protect your employer's interest so that you just don't cross the street and take all the training and everything that they've taught you and then take all their business away and compete with them. So that's where you get the non-compete from. A non-compete clause are enforceable in most states, but you should always check your state law or check with an attorney and have them review your contract. However, if it is enforceable in your state and you have a non-compete, there's normally two parts to it. So the first part is going to be the time period that you're restricted from competing with your employer. That's anywhere from 1 to 3 years typically that I have seen. I've never really seen it shortened less than a year, but it's possible that it could be out there. And then the second part of the non-compete is the restricted area. So for that period of time, you may not become employed in that restricted area. And that can be, this really varies depending on where you are in the United States. It can be anywhere from 1 mile or city blocks, if you're in New York City even, to tens of miles. So it really just depends. And you can always try to negotiate your non-compete clause. It's definitely something that I always review when I'm looking over an employment contract, because a non-compete clause is really serious, and a lot of times clients don't think about it until after their employment ends. And then now there are some serious consequences. They may have to move and leave the area after you've established yourself there, and it's really difficult. And you also don't want to worry about if you're violating your non-compete clause, because that can have some serious consequences. There could be injunctions, which is basically like a restraining order that your employer will get saying you cannot work in that area. Sometimes there are liquidated damages even, which say if you violate the non-compete clause, you have to pay tens of thousands of dollars. So it's pretty serious. The non-compete clause is definitely an area of concern I always look at when I'm reviewing an employment contract. So back to our question at hand, is 2 years reasonable for a non-compete? In my opinion, no. I would always try to encourage our clients to negotiate it down to 1 year or less. 2 years is pretty long, and it gets even trickier depending on how the employment contract is written. And I'll give you an example. Sometimes multiple locations will have that restricted area attached to it. So we'll say something like, you're restricted from 10 miles from any location of the practice. That's concerning because the practice could grow. So there could be additional locations. And if you're restricted for 2 years after your employment has ended and that practice expands and they add more locations, then you have a serious problem there. You could have been working at a location and not violating your non-compete, but now you are because they added a location. So you always want to be really careful. 1 year, in my opinion, is reasonable. But after 1 year, I think it's just too much, and it's hard to keep track of to know if you're in violation of it or you're not. So I would always try to push for less than 2 years. Absolutely. And again, non-compete clauses are definitely one of the most common things that, a prospective employee will negotiate. You always want to be respectful to your employer, knowing that they are going to be protecting their interests, but you also want to protect yours as well. And having to worry about that for over a year is just unreasonable. So, in my opinion, I would always push for 1 year. So 2 years, I would say, yeah, it's unreasonable. 1 year or less. If you'd like any more information on this, or you have any questions, or you'd like to consult one of our attorneys, you can check out our website at Chelle Law, CHELLE law.com. We have lots of content on there about non-compete clauses and anything really that you need addressing any sort of employment contract issues. Thanks.